one of the benefits by going to federal court when you're challenging an APA review is sometimes you still get a judgment. I mean, like a deal. Basically, okay,
Yeah.
we'll approve this or we'll that. And sometimes you see inconsistencies too, where some courts fight you tooth and nail, and then in other courts, maybe the U.S. prosecutor just says, okay, fine, you know what, we'll approve the I-140.
Yeah.
So we're still seeing some inconsistencies.
I've seen the inconsistency, especially in, I think it's the Sixth Circuit DC area, where when these lawsuits for delays, they're just saying there was a 601A waiver taking 2 years, and they said that's not long enough. But Ninth Circuit, obviously, a little more flexible over here, but who knows? It's topsy-turvy, but the inconsistency is pretty deep.
Absolutely. And the only thing I can say, for example, in the EB5 arena, a lot of people had to file for mandamuses in the DC Circuit because they don't live here. So the only venue for EB5 was in the DC Circuit, and the DC Circuit got fed up of the number of lawsuits. So eventually, the DC Circuit and the DC Court of Appeals basically said, "Look, you just wait. A mandamus is just skipping the line," and the government, to me, artificially would make up these processing times, right? Because an I-526 processing time is like 55 months.
Yeah.
And the court said, you wait, because otherwise you're just skipping the line.
Yeah.
So there's bad case law now, specifically in the mandamus context in some courts.